Our next speaker, Stephen Parker. He's a managing partner of the WP&D law offices in Washington, D.C. He works a lot with patent law and with regard to medical devices, and he's also been engaged in remote viewing experiments with the University of Virginia. He studied OBEs and other mental states for over 20 years, and today's talk, sponsored by John Valentino, is the patent hurdles faced by companies seeking to protect inventions in emerging and or not widely accepted sciences. Stephen Parker.
Thank you very much. So now that we start talking about winning lotteries and making money, then all of a sudden the lawyers come out. Yeah. I think I would like to talk about patents and intellectual property. I think it's good for people that are doing research to realize that there are sometimes practical things you can do, and to have a better understanding that maybe you need to try to focus on the business side and try to protect your inventions. Mostly I'm focusing on patents because they tend to be the most important type of intellectual property for inventions and technology development. And some of my captions are meant to be silly a little bit. Okay, physical property, things, bicycles or whatever, everyone knows when you have it, it's your bicycle, it's in your garage. If you don't do certain things, take certain acts, something that you think is your invention won't be your invention unless you follow certain legal principles. It just won't exist. So it's very important to understand certain basic things. Like you could work for a company, develop some wonderful thing and come out and tell everybody about it. A year later, you have nothing. You've just given it to the world. So I think that's a very important thing to understand, at least the basics of what you're dealing with. This basically lists sort of the basic types of intellectual property, patents, as I mentioned, and that gives you the right to exclude. That's like a word that I think most of the people here don't like. Shudder. Exclude others? How could I do that? From making, using, and selling an invention for 20 years. Trademarks, I think people understand, protect names of companies and stuff. But usually your company is not so much based on the name unless you're selling a soda pop or something like that. It's all on marketing. Copyrights, I think a lot of you understand copyrights, doing a lot of publications and things like that. But they generally are not going to be the type of thing that's going to protect a business because they're protecting someone, preventing someone from actually accessing and copying some article or some creative work. Trade secrets, I think, actually is an important area for people to focus on, especially in technologies that take a long time to develop. You're not sure what technology might come out of it. You want to become known in the market and give talks and things like this. But sometimes you have to balance maintaining trade secrets if you see a business side to something. And I always put in contracts. A lot of intellectual property is protected by contracts. You have developers, you have people filming things for you, recording, doing programming. If you don't do the correct contracts to kind of set up your foundation, you can run into trouble. And I just wanted to give you guys a general idea of the types of intellectual property there are. Now I'm going into some of the hurdles faced by people in trying to patent things in these kinds of areas. And so I put this caption, to be or not to be protected? That is the question. Will you protect your invention or will you give it to the world? So this is my being silly, the Jesus patent strategy. Now Jesus decides that he's giving to all, and why protect this thing? You want to get everything out to the public, and you're not in it for personal gain and stuff like that. But I think the reality of our lives, that we need to work and survive, make money, and unless, I'm sorry to put it like graphic, there may be someone be offended by that, I'm joking. But unless you're really willing to put your whole life out there and give it all up, I don't recommend that first strategy. I think approaching patents and realizing that if you can get a patent on something, maybe certain technology you can if you don't want to make money on it, you can at least steer the community. You know, if you patent something, perhaps you can actually help guide the direction of where it will go. And if you want to get into research, you need funding and investors, and usually they like to see patents and protection and things like that. Now here's the second hurdle, which I kind of would say is really a lot of hurdles in there, is that for patents, usually you're focusing on technology that's developed, a new widget, a new projector, something things that people can look at and see. One of the standards for obtaining a patent is that the patent has to have utility, usefulness. And there's case law and things that have developed over time, basically setting forth certain things that you couldn't patent. You can't patent something that covers basic law of nature. And a lot of things that we're talking about are perhaps basic laws of nature. Can you heal by certain thought processes and things like that? As well as the patent office, and I was actually a patent examiner in the 80s, and I remember one of my friends coming in and going, look, someone's applying a patent, they have a wheel that basically they think rolls further than the regular wheel. It's like, they were so excited to be like rejecting it on being a perpetual motion machine, because that's not possible. So the patent office will basically look at some technologies, and if you say, I have an invention that you can then, based on your thought process, change the color of the light in your room, and I think you will get the patent office having a difficult time accepting that. Whether or not there might be some basis or articles and things that many of you have written that would support some of these things. As well as basic mathematical algorithms. Some of the things that we're talking about, statistical methods for improving accuracy for winning the lottery. Those types of things are hard to patent. So some of the things that you're coming up with you might see benefits to it, but sometimes it's hard to patent it. Sometimes you can patent an algorithm in some kind of context, but you're definitely dealing with types of inventions that are in areas that are kind of on the fringes of patentability, and probably one of the reasons that most people here don't even think in terms of patents, I would think. As well as things that are purely mental steps. If it's something that's just carried out in your head, patent office doesn't care. So they basically want something tied to a machine. However, there's a lot of mental steps and a lot of things that one goes through in remote viewing and a lot of things where I think there's a lot of possibly invention. I think maybe there's a issue there as to whether it's old knowledge or whether some of it actually can be developed. That probably goes into someone else's lecture. Recently, the Federal Circuit, which is the patent court in DC, has changed the law pretty substantially that limits the ability to patent software and business methods and general methods. Previously, as long as the invention created some kind of a tangible result, I don't know if anyone has patented things, maybe they've heard this, then the courts here would say, yeah, some tangible result, printed out a number, some kind of value to estimate the likelihood of winning the lottery, yeah, that's a tangible result, and they'd let you get a patent on it. Now they actually want you to create something that's more tied to a machine, and actually either tied to a machine and the functioning of the machine or transform some article of manufacture. The reason for that is more because of all these internet patents that came out, and there's a lot of people trying to patent everything on the internet, like clicking on one little thing and to get money. But it's just something to understand that it's a little bit difficult to obtain patents in these areas, but not totally impossible. And then also you can't get patents on methods of actually treating patients. That's the whole idea, is to keep that open to the public. There are some limitations on that. One of the things one can do is if you have invention that's in some area where the patent office might consider that it has no utility or not believe that it will work in the way it's intended to work, you could basically patent the device focusing on another utility of it. Maybe it creates a novelty item, a way for amusing yourself, of getting some